advised, the Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time and date scheduled for our cause number SA24-0206, Crosby versus the Honorable Fish, State of Arizona. These proceedings are being audio and video recorded as well as live streamed, so please introduce yourself and your client at the beginning of your presentation. Each side will have 20 minutes in which to present their argument. It's up to you if you want to save any of that for rebuttal. We have read the briefs, discussed this case in conference, and are familiar with the facts. Given that, are you ready?
Yes, Your Honor, thank you.
Please proceed.
Morning, Your Honors. Dennis Wolenchak for Tom Crosby. Basically, Your Honor, we're here on the special action because Mr. Crosby, in this unprecedented criminal prosecution, could not have violated the statute as charged. The statute is charged for a Class 5 felony. And frankly, to boil this all down and to simplify it really, subsection C of 1004A, 16-1004A, or excuse me, 648, I apologize, is very clear that he couldn't have committed a crime here because at that time, the Secretary of State had the authority to postpone her canvassing by up to 30 days for incremental periods of time. In fact, the canvass in this case occurred on December 5th without a hiccup, which was the date it was supposed to occur. Quite frankly, I think this case was just overcharged. It probably, at most, at best, could have been charged as probably a Class 3 misdemeanor, maybe a Class 6. But it was charged specifically under this particular statutes, 1004A and 16648. And as such, they have to meet those elements, and they can't, and they frankly didn't. There's no.
Are you saying let's say they had delayed until the day before the extra 30 days is up? Are you saying there could have been a crime then?
No. Well, that's a great question, actually. I hadn't thought about that. But in that situation, as long as the canvass occurred on December 5th, I don't think there would be this crime.
But doesn't the Secretary of State presumably need a little bit more time than it's not just one county, so if everybody just waits until the very last minute, isn't that problematic?
Yeah, I mean, it could be, I agree. If it was something that was knowingly done to cause that discharge of that duty to be.
But isn't that the allegation here, though, that it was knowingly done?
Well, it may be the allegation, but it's not the facts that have been established by them.
That's what trials are for. Let's assume that, for the sake of argument, that you present that to the jury. Isn't what you're claiming an attempt?
Well, there was no attempt charged here.
Well, it said lesser included. It's always presumed. So even if you argue, go to a jury, and you're presenting this case, and the jury believes what you're arguing, then they could return it an attempt.
Well, yeah, I mean, I don't disagree. A jury could find for us, absolutely. But the point is, why do we have to go to a jury?
For an attempt.
Well, there's no attempt charged here.
It doesn't have to be. That's my point.
Yes, that's a separate crime.
It's an attempt. It's a lesser included. And it's necessarily included within the greater charge.
Well,
so if the jury believes that, yes, you didn't succeed in your attempt to interfere, they could still return an attempt verdict.
If it's not charged, you're saying?
Well, you don't have to charge it.
Well, first of all, let's talk about that attempt issue while you're on it. There's no evidence here of any attempt to do anything. What happened was the chairman of the board actually misagendized the item. It was clearly to be set for November 28th, which was the date that it should have been, and Mr. Crosby wanted it heard on that date. All he had asked, and the other supervisor had asked, was that there were certain questions raised at the November 18th meeting that they wanted answered as part of the process of approving of the canvass, because people had come to the meeting and had questioned these issues. And as public officials, they felt it was important to do that. No indication here of any attempt at all in the facts of this case, at all. And in fact, for purposes of the immunity argument that we have, the purposes are irrelevant, actually, under the case law. So the facts are that clearly he wanted this heard on November 28th. It was set to December 2nd. He wanted it heard on November 28th. It was only set to December 2nd because the chairman had misagendized the item and it could not be, according to parliamentary procedure, believed at that time, and that's the facts, it could not be heard that date.
Then the judge ordered him to go back and do it, and he didn't show up.
That's not a crime. That's correct.
Okay, well, whether it was done intentionally or not would be a fact question for the jury, wouldn't it?
No, there's no crime to not showing up at a meeting. If there is, I'm not aware of it. So it's not a crime charged here. It's not even...
But it seems like there's at least an inference of a lesser included
Of
an attempt to delay the canvass.
Well, again, delay what? That would be as I said, a class 3 misdemeanor.
It's a lesser included, and if we're...
Well, lesser included of what? It's still a class 3 misdemeanor, at worst a class 6. It's not a class 5 felony because he's not interfering by doing that with the Secretary of State's duties. There's no evidence of that, even if it was continued to December 2nd, even if he didn't show up on December 1st.
The evidence is that the suggestion is that there's an intent to delay it, to interfere with the Secretary of State carrying out her responsibilities, and if they don't prove that, but prove a lesser included of just an attempt, how do we just dismiss altogether?
Because even assuming that there is a lesser included of an attempt, it doesn't change anything here. The facts are what they are, which is that it wasn't continued to the last day. It was continued to November 28th, which was the date it was due. It couldn't be heard on that date. It was therefore continued December 2nd, which in no way under this crime charge or even an attempt of this crime charge interfered directly with the Secretary of State's duties, because she had no duties as of November 28th. The only duties that she was discharging would be on December 5th. And so even assuming it's an attempt, it's still not a crime as alleged.
That's a very narrow view of what her duties are in canvassing. Why, if that is her only duty, does she require, or does statute require, that it be canvassed on the 28th by the counties and give her time until the 5th to actually do the official state canvass? Why is there that delay in time if that's all she's doing?
I have no idea. I don't know why. I'm assuming it would, I can't assume, I don't know why, to answer your question honestly. I don't know why, but it doesn't change what we're here for today, which is whether this is either an interference with any duty she has of the 28th. She clearly doesn't have any duty on the 28th. I don't think that's in dispute.
She does have a duty to collect the canvasses from the various counties. That is part of her job, is it not?
No, not as of the 28th. There's no law saying that at all. I don't know where you're getting that from. I don't see anything.
The law says you're supposed to meet and do it on the 28th.
Yes.
To give it to the Secretary of State.
Well, it doesn't say to give it to the Secretary of State. That's my point. But even if you didn't...
Just put it out on the street and just leave it on the side of the street?
I mean...
You canvass and you send it off to the Secretary of State.
Yeah, but there's no law saying you have to hand it off on the 28th, is all I'm trying to say. And what I'm saying is, there's no duty that she has to collect it on the 28th. Nothing in the statutes that says that, or gives notice of that as a crime, a Class 5 felony. That's the whole point here. Whether you consider it attempt, whatever you consider, whether you consider it dereliction of duty, Class 3 misdemeanor, Class 6 for changing the date, whatever. It's not a Class 5 felony as charged. That's all I'm saying. It clearly doesn't meet that test. And it didn't interfere with any duty. In fact, the canvass went as planned on the 5th. There's plenty of time. There's no evidence in this record whatsoever that there wasn't sufficient time for the Secretary of State to receive it. It was received appropriately. How it was received, as you point out, whether it was by court order or not, is really not relevant because, again, the Secretary of State brought that action, and that's fine. It was only intended to
get... because the other Board of Supervisors showed up at the meeting, and so they had 2 votes, and they could certify the canvass, correct?
I'm not sure what the point of that is. I'm sorry.
Well, you say, oh, he just didn't show up. But if the co-conspirator had gone along with him, then it wouldn't have happened on that date, right?
Well, again, I don't mean to quibble, but when you say co-conspirator, if you're saying legislators in this situation are co-conspirators because they vote alike, I think that's an absurd proposition that the state advances. But to get to your point, again, I repeat, not showing up is not the crime charged here. It's not even on the radar here, okay? So that's all I'm saying. It's not a crime. We're not here to talk about that today because it's not charged. What is charged is a Class 5 felony, which has to meet certain standards. And, by the way, is immune, well, I'm here on it, from prosecution. It is clearly under the case law that we cited, an act that is beneficial to the legislative process, attendant to the legislative process, whatever words we want to choose, under Mesnard or the
How is
other.
it legislative as opposed to just an administrative function? What rules are being established? It seems like an administrative function to just simply...
Well, with all due respect, Judge, I don't agree with that. I don't think it is an administrative function at all. I think it's clearly a legislative function because they're voting on whether to approve a canvass. That is clearly a legislative vote. And any continuance attendant to that is another matter attendant to a legislative vote. No different than the cases we've cited.
But you're saying you can vote on whether to do something? The initial objection was we think all of the ballots should be hand counted. And
yeah, but that's not really relevant to this issue.
But that was kind of the reason for delaying.
No, it wasn't actually. It had nothing to do with it. The only reason to delay from the 18th again to 28th, I'll repeat, had nothing to do with any of that stuff. That's old history.
Misagendized.
Absolutely, and that's exactly the fact. So there was no effort to harm the Secretary of State or her canvassing on the 5th. And if there was a vote to put it to the last minute before she had to do that, going back to your first question, that's a different set of facts, but I can understand that there may be some specter of concern that might have been the intent. But that's not the facts of this case at all. There was plenty of time for her to do the canvassing.
But plenty of time seems different than you can draw an inference that was the intent. And that seems like a very good argument to make.
But what's the basis for the inference?
That they wanted to delay and not have the election certified.
Well, then why would they have voted to put it to the 28th when it was due?
After the Secretary of State files a mandamus action to get them to do something.
No, but I'm saying they voted to put it on the date that it was due. So that's clear to me that there's no intent to delay the date that it was
It's
due.
clear to you, but it's up to the jury to decide, right?
No, I don't think it is, quite candidly, because I don't think there are any facts that they've established to meet these set of requirements for the statutory crime. There's just nothing. As I said, just think this through. If they were going to attempt or even to delay this to harm the discharge of a duty, which is what they have to do, they wouldn't have voted to continue to the 28th. The facts are undisputed that they did that with the understanding that they would get answers from the Secretary of State that they were unable to get on the 18th. That's why it was rescheduled, and it was intended to be voted on that date as the law requires. Unfortunately, the Democratic supervisor chairman misagendized the item and left all that out. And so they couldn't hear that, and that's what they decided to vote to continue for a few days. Now, if their intent was to harm the Secretary of State's canvassing, I submit to you respectfully they would never have just continued it to December 2nd, which was the next available date. They would have continued it forever or come up with some phony excuse to continue it past the Secretary of State's canvassing, or, as Judge Catani points out, put it to the last minute before she has to canvass or something. But if she has an administrative duty as well, and it's a non-discretionary duty, you could argue, and I'm not going to because it's not the facts of this case, but you could argue that if she received it any time before the canvass that she did, that it was in and it was probably fine, it didn't affect her for this crime. But, I don't want to get off on a tangent. The point is that wasn't the facts here. It's not what they did. It's not what they intended to do. And there's no evidence in the record whatsoever that's ever been presented or provided anywhere in the motion practice or any place else that there was an intent to harm the Secretary of State's canvass. That's the whole issue, really. So I would like to reserve some time, but I just want to say that on the immunity issue, if people in this situation or a board of supervisors are being charged with crimes in situations such as this, where, by the way, there is no case law that I've seen that's applicable, and I don't want to spend a lot of time on it, the Hunt versus Campbell case that they cite, but it's not applicable in terms of whether this is a non-discretionary ministerial duty. I haven't found any case law that's directly on point that says it is. And I'll just say this final thing on that. If it were, then why require, to get back to an earlier question, or your question, Your Honor, then why require these people to even have to vote on it? If it's just a rubber stamp, I'll say, then why did the legislature even require a vote? There's to be no discussion, there's to be no understanding of whether it's a legitimate candidacy. They just have to sit there and stamp whatever's put in front of them? That seems to me ridiculous. So, again, I don't know the reasons why the legislature does a lot of things, and I won't lie and tell you I do, to answer your question earlier, but I also don't know why they would have done this either. It seems to me that there is some discretion, and all they wanted to do is get some answers to some questions that were being raised by their constituents. Now, that seems to me what a good public official should do. And if there was any evidence in the record that they were doing this, to get back to Judge McMurdy's point about conspiracies, that would be fine if that is the evidence. There's nothing about that. It's simply they voted together. And now the state has claimed, well, that's a conspiracy. And I'll just submit, if this becomes a conspiracy under the law, that legislators, board of supervisor members, council members, whatever, vote together on something because they happen to agree on it, and the state comes in and claims that to be a crime, and God help us all. I'd like to reserve the time unless there are any questions. Thank you.
Mr. Willencheck.
I can't button this, I've gained some weight. Good morning, and may it please the court. My name is Casey Ball, Assistant Attorney General here on behalf of the state. I think I'll start with the indictment issue because that's where most of the argument was. And I want to frame this in the proper context, especially based on Judge McMurdy's questions. In 2013, our Supreme Court in State v. Otter explained that motions to dismiss under Rule 16 are not a means for testing before trial whether the state has enough evidence to prove the elements of an offense. Most of what you just heard is the state doesn't have evidence. They haven't shown evidence of intent. Those are all great arguments for a Rule 20 motion or a closing argument to a jury, but they are not the proper questions to ask when challenging an indictment. The question is the indictment sufficient? Does it give notice to the defendant of the charges alleged? And is it factually possible to commit the crime? This is very different than Majack v. Granville, a case where the court took special action on a motion to dismiss on the sufficiency of the indictment. There, the defendant was soliciting what he thought was a young teenage girl. Turns out it was a reporter conducting a sting operation. At the time, the luring statute provided as a defense, or provided that it was not a defense if the person posing as a minor was a peace officer. There was no factual dispute here that the person posing as a minor was not a peace officer. So the question turned on, under this case, under the facts alleged that he was luring a reporter, could he have committed the crime? Could he admit to all of the allegations in the indictment and still commit a crime? And the answer is no, because it wasn't a peace officer posing as a minor.
What's to Mr. Willencheck's argument that you're being charged with a crime for voting, and that's the duty of a supervisor is to just vote to accept. If it's simply an administrative act, why does it call for a vote? And why would that result in a crime based on your vote with one of your colleagues?
So the fact that there's a vote does not give somebody legislative immunity. That's made clear by this court's case in Montgomery v. Mathis, where the Independent Redistricting Commission deliberated and then voted on a mapping consultant. There was a public records request for records pertaining to that, and this court held it doesn't matter that there was deliberations voting. It's a mapping consultant. It has no prospective discretionary policy-making aspect to it. It's not legislative in nature. So just because it's a vote doesn't make it a legislative act. Instead, there has to be some forward-thinking, prospective policy reason, and there's nothing in the statute that allows for the county board of supervisors to contemplate regulations or anything regarding the canvass. It is simply passing the numbers along. We start with the precinct level and we move up to the Secretary of State's office. It's getting the water to the end of the row. Whether that's the best system designed is a question for the legislature, and they are free to amend it, and they have amended as shown in the recent amendments to the
So
statute.
You're saying you don't even have to allege any type of harm to the Secretary of State in the...
It's the interference is the crime charged here. And so the delay in transferring the canvas to the Secretary of State, if it interferes, which does not mean completely obstruct the statewide canvas, that's not the natural, ordinary meaning of interfere. Interfere isn't defined in the statute, but we look to the plain meaning, and that's hinder or impede or obstruct. It does not mean completely prevent.
So you're saying anytime there's any delay at all, there's arguably some interference or an attempt to interfere with the Secretary of State carrying out her duties?
It's going to be on a case-by-case basis. Here, the Secretary of State had to go to court, get a mandamus action, and force the board to comply with its obligation.
So if Mr. Crosby failed to do so, wouldn't the remedy be contempt in that case?
That's if for failing to comply with the court's order. That's a possible charge that he could have, contempt of court. Here, by the time the court order was on December 2nd, he had already blown past the deadline. The deadline was non-discretionary. He had to canvass by November 28th. Regardless of whether he wanted a debate on the efficacy of the tabulating machines, the statute said you must canvass by November 28th. The Election Procedures Manual, which had the force of law, said you must canvass by November 28th. And so,
But all of that, okay, so you've got this November 28th, and it happened before the Secretary of State was required to produce the canvass of the entire state. So when we look at that, how did it interfere with the Secretary of State's duty?
because there's a process that goes on. As you mentioned in your question, there's a delay between when the counties canvass and when the state canvasses, so that the Secretary of State can collect all of the canvasses, put them together, get them prepared for the statewide canvass, and to allow for the possibility of any legitimate delays. Under the statute at the time, there was an opportunity for the counties to delay day by day if a precinct hadn't reported. That's been removed from the most recent one. But at the time, that was a legitimate delay. Now, here, Cochise County, all the precincts were reporting. There was no lawful means for the county to delay beyond November 28th. The statute contemplates, or not the statute, it's ARS 16-407.3, contemplates that there might be times where an election deadline needs to be modified. It criminalizes the modification of those deadlines if the court doesn't give an order to modify it. They have to go to court first. So let's say Cochise County actually had a problem in this case, and they needed to delay it beyond November 28th. They go to court, and they get an order from the court modifying that deadline. They don't just blow past it and set a new date out in the future for whenever they care. They don't hold hostage the canvass until they get what they want. Those are the unlawful acts here.
Was this held hostage? It seems odd that there's absolutely zero delay. Secretary of State's able to carry out her duties. If they had just kind of made some musings at some point, I wish she wouldn't certify it, or I wish we could delay that. That's a conspiracy. It's a crime when nothing that they've done actually resulted in harm to anyone.
So, I mean, the ultimate canvass occurred. I would push back on that there was no harm. The Secretary of State had to go outside the normal protocols, expend resources getting a mandamus action.
Mandamus, and then there's a remedy if they don't comply with that. They can be held in contempt. Why isn't that enough of a remedy rather than going after legislators criminally?
So as far as, I'll take this in two turns. So more than one statute can criminalize an act, and prosecutors have discretion to select which offense to charge if more than one. So you have contempt of court, or in this case, interference with a public official. Moving to the legislative immunity, which I think is the second part of your question, there's a well-defined and well-accepted exception to legislative immunity, which is you don't get immunity for ministerial acts. If you have a duty, a non-discretionary duty to canvass, and you fail to do it, you don't get immunity for your willful failure to comply with your duty. Here, Crosby was informed multiple times of his non-discretionary duty to canvass the results. He blew past the deadline. He didn't show up even after the court ordered him to. This is way outside the scope of discretionary policy-making decisions that have some forward-thinking policy aspect to it. It is.
So is a canvass simply adding up the numbers?
Yes, it's math. It's
Then
getting the.
Require them to vote on it. I mean, why? What's the point?
I can't speculate as to why the legislature thinks this is the best. It could be that it's a public, much like our oral arguments here, right? It's a way for the public to see the process in action. I don't know that that's really the purpose. It could be, but it doesn't matter. The statute doesn't give discretion. It says you shall canvass by November 28th. There's no exception for unless you have questions about the validity of it. If you have legitimate questions, another statute contemplates that you go to court and you get an order. That didn't happen here. Crosby never sought an injunction to modify the deadline. Instead, well, go ahead.
What do you make of Mr. Wolinchuk's argument that this will chill people from wanting to engage in public office if people are getting prosecuted for this kind of action?
So, I mean, that's a concern it's raised in a lot of the legislative immunity cases, right? That you don't want to chill speech or debate or legislative acts. But we are far removed from legislative acts. Public officials have duties.
But they did take a vote that was called for.
Again,
like a bit of at least
the fact that
close to being a legislative act.
The fact that it's a vote is not enough. It has to have a discretionary policy. It has to bear the hallmarks of legislation, right? It has to have some forward-looking perspective policy angle to it. There's no policy in adding up numbers and transmitting them to the Secretary of State. He may have questions about the election that are separate, but he tries to combine the two and say, well, I've got questions about the tabulating machines, and so I'm holding hostage the canvas, which is just math. It's just sending it upstream. They're separate.
In this circumstance, it appears that Mr. Crosby was warned by multiple people that this was what should happen. But let's take this in a hypothetical and say, no warning, no advisement, and just failed to do it. Is that different?
Well, ignorance of the law is no excuse. So, no, it's not different if he has a non-discretionary duty, if it's part of the statute. Then ignorance of the law is not an excuse, and you'd still go to trial and still be able to show a violation. Now,
it would make your job a lot more difficult under that scenario.
It would. It would also. It would call into question the intent for because he's not charged with failing to comply with a duty. That's a separate statute. He's charged with interference with an election official's duty. So you have to, at trial, the state has to show that his intent was to interfere with the Secretary of State's duty to canvass. Right.
I don't know if you have any more questions on this topic, but I wanted to talk about venue.
Yes.
For a minute. The constitutional provision is not a venue statute. Now, our Supreme Court has said that.
Correct.
But why would you file it in Maricopa County when all of the witnesses to this alleged crime are going to be in Cochise County?
Some of the alleged witnesses, some of their witnesses. We've got several that are part of the Secretary of State's office that are up here in Maricopa County.
Okay.
The prosecutors who are...
Yeah, they're not going to be your main witnesses, are they?
I'd have to go back and look at all of the witnesses we've noticed.
Well, the Secretary of State's going to say, yeah, we didn't get the canvas. There you go. Next witness.
Right.
So the main witnesses are going to be the Cochise County folks, and you file it in Maricopa County.
So the grand jury found that the crimes were committed in both Cochise and Maricopa County. Under that circumstance, the state has the option to choose which county to file the charges in. We elected Maricopa County. The prosecutors running this are in Maricopa County, and as a general matter, that's our policy, is that when...
Does the court have any discretion to determine, yeah, this is better suited in Cochise County?
I'm remembering some cases in my research from a couple months ago where if it's clear from the record that the prosecutor is just trying to harass the defendant by bringing the charges somewhere else, I think there's a due process concern at that point. There's nothing even alleged here that that's the case. The question
Was that
is,
even argued to Judge Fish?
No, it wasn't. So that's not an issue here. There's no evidence in the record that that's the case. It's simply that when the state grand jury found that it occurred in both counties, the state elected to charge it here in Maricopa County. Now, the only count that's at issue right now in the menu is the conspiracy. So the trial's moving forward on the interference here in Maricopa County anyways. We recognize the language about not bootstrapping a count that shouldn't be in the county if venue is not proper, but venue is proper here. The act of delaying the transmission, the duty was for the transmission of the canvas to be in Maricopa County on a date certain, and he failed to do that. Just like in Alsea, where the mother failed to bring the kids back to Navajo County even though she never was physically in Navajo County, it was still, venue was proper in Navajo County, much like the conscientious objectors in Johnston, the Supreme Court case. The duty to report to the hospital, the venue where the hospital was where the venue was proper. So much like that, the canvas had to get here to Maricopa County to the Secretary of State's office, so conspiracy is properly in Maricopa County.
Could I just go back to the, if there's interference when there's absolutely no delay in the Secretary of State carrying out her duty, you're just saying it seems odd to criminalize conduct by legislators that doesn't result in any damage to anyone. Legislators who are responding to questions from constituents, they hem and haw a little bit, but they're being responsive. Nothing's actually delayed. There's still a crime just because they thought for a minute we'd like to delay this. That ends up being a felony.
It's not that they had a thought for a moment. It's that the Secretary of State had to go outside the normal protocols, expend resources, and get that mandamus action. If you read the statute, it's at any election interferes in any manner. The language is pretty broad. It doesn't require a complete obstruction or a actual delay of the statewide canvass. In State v. Otter, the case I started with, there was the question about the factual impossibility of a reverse sting operation. The defendant's brought into the warehouse, is given possession of the marijuana, but the warehouse is surrounded by cops. He's never leaving.
I'm very much familiar with that case.
Yeah.
But you're saying this is just entirely up to the discretion of the prosecutor, as long as there was even a scintilla of evidence that there was an intent to interfere with the Secretary of State's duties, that's enough to go after legislators?
If there's probable cause that there was an intent to interfere and an interference, now the state is going to be held to its burden of proof at trial on this, but the degree of interference or the scope of the duty are going to be questions that can be litigated at trial. They're not subject to a Rule 16.4 motion. Going back to Otto, which we're familiar with, this is not the time to test the state's evidence at this point to prove the elements of the offense. Does the indictment sufficiently allege to put the defendant on notice?
Is it true that it could be an attempt?
Yes.
I mean, if the jury ultimately determines that she was not interfered with.
Yes, and then it would be possibly a lesser included. If we get to trial and the state can't prove an actual interference, but there was clearly an intent to delay the statewide canvass, then yeah, it would be an attempted interference, which would then drop it down a class under the attempt statutes. If the court has no other questions, I'm happy to sit down, but I want to make sure I answer everything you need.
Mr. Willencheck, and I wrote this down, says his client had no intent to harm the Secretary of State's canvass. Is that required?
It's an intent to interfere with an election official's discharge of her duty. So the way that we've charged it under the indictment, and I think I brought that up here. If you look at, I think it's Appendix 4 of the, I didn't bring it up. Basically, we charged it as the delay in the delay of the county canvass and the delay of the transfer of the canvass to the Secretary of State. I believe we specifically alleged Secretary of State in the indictment. So that's the facts that we're operating under the indictment.
So harm is not required.
It's interference. Harm and interference, I think we're using synonymously here, right? Interference under its natural meaning is a hindrance, an obstacle. It doesn't mean a complete deprivation of the ability to canvass the statewide canvass. All right, thank you. The state asks that you decline jurisdiction or, in the alternative, deny relief. Thank you.
Well, Your Honors, first of all, under 16.4, which we're proceeding under, and we did proceed under, you can basically admit the facts and still contest the crime, and that's what I've done. There is no crime here noted, no fact noted regarding any delay in transmission, intent to delay, actual interference with any duty of the Secretary of State at all. There were no duties that are even listed of the Secretary of State until December.
Mr. Willencheck, I was the trial judge in Otter. That was me. And everybody agreed to the facts, and I said, boy, that's not even a crime. And so I granted the defendant relief in that case. And the Supreme Court slapped me silly, saying that's not the function of a Rule 16 motion.
Well, that's amazing, because that is the law.
It's amazing that I granted the defendant relief, or
That is the law, that you can, that the Supreme Court has said that you can admit basically to the facts.
in that case, they reversed me in a heartbeat.
Then if that's the court's ruling, then I'll take it up with the Supreme Court, I guess. But I don't know how to answer that really.
No, I'm just saying.
Yeah, no, I know.
They specifically said that that's not how you test.
Well, how do you then? I mean, how would you? The fact is that this is a specific crime charge, and the interference clearly on its face, has to be with some, I assume, specific duty that they have to allege that the Secretary of State had. There's no evidence whatsoever, or even allegation, that there was an attempt to delay transmission. It wasn't delayed, and in fact, there's no...
But the fact that it wasn't delayed doesn't mean that there's not evidence of an intent.
Well, it does, because there is no evidence that there was any attempt or even intent to delay transmission, is what I'm saying. In fact...
Isn't that a factual question that goes to the jury? At this point, what we have is, the statute says canvass on the 28th. We don't have a canvass on the 28th from Cochise County.
But that's not the crime.
The Secretary of State has to go to court to get a court order.
She doesn't have to go to court. I don't know where that came from. That's another point I want to make. She decided to go to court, but he keeps saying she had to go to court, or you're saying it. She didn't have to go to court, and if she did, what they obtained was a ruling of getting it on December 1st, when in fact it was continued to December 2nd. I don't hardly think that that constitutes a major difference of one day that they had to obtain. And there's no duty alleged that she had as of that date. None. Now, they even in the conspiracy charge claim that her efforts were somehow impeded with, quote unquote. What efforts? No one knows of any such efforts. They haven't been alleged anywhere. There are no efforts that the Secretary of State has, in fact, until...
We can say at this stage, I mean, there's presumably something that she does prior to just putting her stamp on it. It's not simply a 30-second job that the Secretary of State...
Well, they're claiming it is. They're claiming it's a non-discretionary administrative duty, and it's a rubber stamp, just like it is for my client.
She has to gather it from multiple counties. And they're, your arguments are persuasive on the merits, but it's hard for us to get there and say there's absolutely no possibility that the state can prove what they're alleging.
Well, what is that possibility? We haven't heard it in all this time.
Well, but they're saying you've interfered because the Secretary of State needs some time to do something. You have interfered with the actions that she has to take to carry out her responsibilities on that date.
With all due respect, I don't know what those actions would be other than receiving transmission of those tallies that they claim are non-discretionary and are administrative. There are no efforts, duties, or anything else she has. And as you know, there's a vote by the governor or the attorney general on the date when certification has to occur. That's all they do. They meet, they vote on it, and that's the end of it. And that's their position. But what are the efforts or duties that she has before them? No one knows, and they've never been alleged. But to allege this kind of a crime on those facts should not compel a legislator to have to answer for a Class 5 felony for voting based on Robert's Rules of Order procedural snafu that he didn't create.
Thank you, Mr. Willencheck.
And I'm sorry.
At this point, time has run. We will take this matter under advisement, issuing a written ruling in due course. We thank you for your arguments here today as well as your briefing. We are at recess.